Mokgoro was not in the NPA.
Yes, no, absolutely, I will agree with that, and I don't blame him for the period after that.
Yes.
I'm just saying that if he did not withdraw the charges in 2011 and let us go to trial with it, it would have been finalized in 2012 already. And Mdluli would have faced justice for discharges in 2012 already.
Is it then fair to think that, to say that within the NPA, nobody except yourself and Advocate Breitenbach think there is a prima facie case against Richard Mdluli?
No, there's a lot of people that think so. Advocate Mr. Yati thought so. Advocate Paul Lowe thought so. Advocate Arno Rousseau thought so. They still think so. The major problem now is that when they made a presentation to Advocate Abrams, there was a question surrounding certain classified documentation which for some unknown reason, and I'm not a personal witness of this, so please bear that in mind, but for some unknown reason the National Commissioner of Police do not declassify certain of these documents. And we believe, at least then the prosecutors, that there's absolutely no reason why the National Commission should not declassify those documents. But those documents have got more to do with the China trip, the Singapore trip, the renting out of your own flat to crime intelligence as a safe house, etc., etc. And then the appointment of people. It looked at one stage, and it's a serious matter, but I mean it looked at one stage of crime intelligence was the personal business enterprise of Lieutenant General Mdluli, because family members of him and his wife were appointed to crime intelligence left, right and center.
But do we have that evidence for us?
We have the evidence in the reports that have been provided by the various prosecutors that confirm that those were the allegations made, and that the declassification has been the impediment to the ongoing prosecution. So what Advocate Ferreira is saying is indeed confirmed by the prosecution reports on record.
Thank you.
I will put it to you that the declassification of the documents also related to the corruption charge. The initial was withdrawn by Advocate Mokgoro. It also related to that.
No, I would not be able to agree, because the documentation of the two, of Atlantis Nissan and of the other, Leo Heiser, is public not public documents, but it's public business records of those entities. We would not need to declassify that. The only possible declassified document that may be necessary in the prosecution is, I think, General Lazarus signing some sort of a memorandum saying they must purchase a 3 Series and a 5 Series BMW. That's the only document, and from what I'm telling you now, the memorandum doesn't give names and any secure detail that may compromise any operation. So there's absolutely no reason why that specific document cannot be declassified. But what I'm proposing to you is that even without that document, the prosecution on the cars can continue. But I think the belief is at one stage that if it took this long, you may as well then charge him with all the charges in one trial.
I will revert to the issue of the declassification of the documents in regard to the to the motor vehicles. So in regard to the other charges, what was wrong? Why couldn't prosecution? Let's accept that he withdrew the fraud charges or corruption charges. In regard to the other charges, what is the problem now? Because I'm referring to those relating to the trip to China. What is the problem? Why cannot prosecution ensue?
I wasn't personally involved after a certain date, but what I am informed about is that the declassification of those documents is a problem.
Yes.
And at the meeting that Advocate Lowe and Rousseau had with the NDPP, he undertook to personally take it up with the National Commissioner, that the National Commissioner declassify those documentation. That was the last I heard about it. Whether the National Director sent a letter or not, I'm not privy to. And whether the National Commissioner has actually given attention to the case, I'm not sure.
And this is 7 years later?
Unfortunately, yes.
I'm still dealing with the submission that will make that you are biased. Just want to refer you to paragraph 9 of your affidavit on page 2.
I have it.
Where you say that as soon as Advocate Mokgoro started engaging on the merits of the prosecution, I was concerned that this was directed at stopping the prosecution. This was informed by the fact that he was dealing with the representation as opposed to the DPP.
That is correct, yes.
Is that the only reason why you thought that? Is that the only basis upon which you based your concern that because he was engaging on the merits of the prosecution, it was directed at stopping the prosecution? Merely on the basis that he was dealing with the representations as opposed to the DPP?
Well, yes. If the DPP in North Gauteng suddenly starts entertaining representations from an accused that's been prosecuted in the Cape Town High Court, you would start to worry, but why does the DPP in North Gauteng have anything to do with the prosecution of a suspect in the jurisdiction for the DPP of Cape Town?
But he's the head of the Special Commercial Crimes Unit. He's not intruding.
We maybe put that in the correction. The representations are dated the 17th of November. The proclamation was only on the 25th of November. That appointed him as the head.
Sorry, what was that?
Madam,
The representations are dated the 17th of November.
Madam,
I suppose what the issue is, why do we not ask that in re-examination?
Yes. I think with respect to my colleagues, we didn't interfere when she laid evidence at length, leaving out numerous documents and not referring to all sorts of things. We'll deal with it. I think unless there's an unfairness, a serious unfairness, she shouldn't be leading evidence herself. We've got the documents. The document shows he's got a letter of appointment from the minister dated the 7th of November saying he's appointed from the 1st of November. If we want to now get onto the record. The proclamation was a little bit later, but the appointment letter says he's appointed from the 1st of November. For whatever, we can argue till the cows come home about what all of this means in due course, but I don't think it's right to interfere, and this is like the third or fourth time that our cross-examination is being interfered with, madam.
We as the panelists are burning with questions, but we feel that we should let the cross-examination run as smoothly as possible. And I think it is true. We should appreciate the fact that you're going to have an opportunity to re-examine. You might want to preserve those for re-examination.
With respect, Madam
You
Chair.
understand the errors that you see, and they might be disturbing, but I think reserve those for re-examination. Yeah, Mokgoro.
Thank you. Advocate Ferreira, I was just dealing with the I was dealing with the issue that trying to elicit, a clearer answer from you to say when you say that that when Advocate Mokgoro started to engage on the merits, when you say as soon as he started to engage on the merits of the application, you then was concerned that that was directed at stopping the prosecution. My question was, and you say the reason was because he was dealing with the representations as opposed to the DPP. My question was that the sole reason why you were concerned that it was directed at stopping prosecution?
No, but no. If you look at our memo, We at one stage said that we should advise that he should actually withdraw from the decision-making process because of his involvement in the Jackie Selebe case, and that the involvement of him and Mudluli in the Jackie Selebe case is well documented. Now, unfortunately, I don't have in my memory that specific aspects anymore, but we were concerned that there was a prior relationship between him and Richard Mudluli and him and Selebe and Mudluli, and we were worried that that was the reason why he is, in inverted commas, interfering in a prosecution that is not his prosecution, that's the DPP prosecution.
So you were worried that he had a relationship with Richard Mudluli?
Well, there was a prior relationship between either him and Mudluli and Selebe, or between two of the three.
But you are speculating.
Well, we say in the memo, it is well documented. But unfortunately, because of the passage of time, I can't remember. I wish we had then, instead of saying it is well documented, documented it in the memorandum, but unfortunately we did not.
But if it's well documented, on that well documentation, is it based on what?
Like I informed you, I can't remember, and unfortunately we didn't write it down in the memo, but we made the point in the memo that it is well documented. But I can't take that further, and I can't put it stronger than that. But
Mr. Ferreira, Advocate Ferreira, being a prosecutor of more than 30 years, you would understand that my difficulty with just taking your word, if you say it's well documented, because I don't know where it is well documented. I don't know on what basis you base that particular proposition. As a prosecutor of 30 years experience, you should understand why I would have such a difficulty.
I fully understand, and
yes.
Like I say, I wish we did
yes.
state it in the memorandum
yes.
rather than just say it's
yes.
well documented.
Yes.
But unfortunately, you can ignore that. I mean,
yes.
I'm not trying to place
yes.
emphasis on
yes.
that,
yes.
And I'm not trying to make anything out of it. I'm accepting at this point in time that he wasn't trying to interfere because he had a prior relationship with Richard Mudluli. I'll accept that, if that's his point as well.
Because I was going to put it to you exactly that he was simply dealing with a representation which was given to him, and it had nothing to do with it was simply him dealing with a representation that he had received as head of the Special Commercial Crimes Unit. I've just been corrected, from the attorneys of Richard Mudluli.
Yes, I accept that.
Okay.
How long are you still going to be, so that we determine if we have to come back tomorrow?
Yeah,
Because Masuku was still going to have the witness. How long are you going to be?
More than 30 minutes.
And tomorrow.
Yes.
Will it
But-
move into tomorrow?
I don't think I'll conclude my cross-examination today.
Today? Yeah,
Yes.
that's what I need to know.
Pardon?
That's what we need to know. Okay, you can proceed. You can proceed. You said it.
Thank you.
Yeah.
Thank you. I now want to deal with the issue of the prima facie case. I know that it's an issue that you feel very strongly about. Am I correct to say that when a prosecutor institutes proceedings, he has to do so, the case has to be founded upon evidence reasonably believed to be reliable and admissible, and continue a prosecution and that you shouldn't continue a prosecution in the absence of such evidence.
I agree with you.
And you see, I dealt with this issue a little bit earlier on when we were talking about the protection of, when we were dealing with the issue that related to whether your view was that Advocate Mokgoro withdrew the charges in order to protect Richard Mudluli. I dealt with this issue. But I want to deal with this issue a bit deeper because it's really at the heart of what he's being accused of. And before doing so, I just want to refer you to certain passages in the Gauteng High Court where certain issues were raised, and so that this inquiry can better follow what I'm trying to address. Madam Chair, I'm going to refer you to the, I'm going to refer just in passing, just to read certain passages before I continue with the cross-examination of this witness. I just want to bring into the fore what the narrative, because it appears to me, and you can correct me, when you talk about the withdrawal of charges against Richard Mudluli by Advocate Mokgoro, what comes into the public mind, I don't know whether it's the press or the public mind, is that...
Which case is that?
The case that I'm going to refer you, my lady, is the High Court decision, the General Counsel of the Bar of South Africa versus Advocate Jiba, Lawrence Mokgoro, and Mzinyati. This is the case where the Pretoria High Court, where the two Advocate Jiba and Advocate Mokgoro were struck off the roll and subsequently overturned. But before I go to the passages.
Sorry, that's the one that's pending in the CC.
But yes, it's the one that is pending in the Constitutional Court, but before I refer you to the passages, I was just saying, you know, the narrative, and you can correct me. If you say the withdrawal of charges against Richard Mudluli by Advocate Mokgoro, then it becomes, then there is a insinuation that he was colluding with Advocate Jiba in order to protect Richard Mudluli, and somehow, because I don't know whether it's somehow then there is a narrative that Mudluli was friendly to the former president. So Advocate Mokgoro protects Richard Mudluli, and Richard Mudluli is somehow closer to the president, the former president. There is always that narrative. You must be aware of that narrative.
Yes, I'm aware of that narrative, but
Yes.
I'm not aware of any
Yes.
substantiation for
Yes.
it or evidence linking
Yes.
it.
Yes.
And that's why we also didn't deal with it like that in our memo.
Yes. But I just want to place it on record because it's an issue that it is widely circulated, and I don't want it to pollute the atmosphere, if I can put it that way.
And you don't expect him to confirm it? You don't expect him to confirm?
Pardon?
You don't expect Advocate Ferreira to confirm that?
To confirm?
The narrative that you are posing?
I think he confirmed it. Unless I think he confirmed it.
About the closeness of Mdluli
Or the former president.
Former president.
To Richard Mdluli.
Yeah.
Okay. Are you also aware of that particular narrative?
Well, the particular letter, I think, has been published in the press or a report
Yes,
on
yes.
the press that he
Yes,
allegedly wrote to the president.
Yes, yes.
I know about it, but I can't quote it for you.
Yeah, sure. The purpose of this is not really it's just to make you aware. For instance, in this judgment,
I'm really not sure what you're trying to do, and I'm sorry to interrupt your cross. I don't understand when you say to pollute the atmosphere. What atmosphere? We are sitting here as a panel to inquire into the fakeness questions, and I'm not sure what you want us to make of this atmosphere. And I think we should be loath to be fetching atmosphere and putting it in here. You yourselves would be loath to have and that is why if you remember 2 days ago, we were quite perturbed about what was going outside. I think the one thing that you want to do, and we all want to do, is to exclude atmosphere, because it's not necessary, it's not relevant. So I'm not sure what you want to make of that statement that you're making.
it's in the judgment which is part of the terms of reference.
That?
The issues that I'm just going to put on record are in the judgment which is part of the...
I make a different point. All I'm saying is I have issues with trying to deal with atmosphere. I think it would be so much easier to just deal with facts. Even if it's his opinions, we can deal with his opinions, rightly or wrongly, in the same way that you say we must deal with bona fides and mala fides. I'd rather we, and I may be wrong, but I'd rather we did that than talk atmosphere.
You remember in both pre-hearing meetings that we had, and this is also part of the terms of reference of this inquiry, we all agreed that we are going to traverse the evidence in all the cases, the judgments which constitute or which are part of our terms of reference. And we traverse the evidence before this inquiry which were traversed in those cases, the evidence. And we are going to do so with a view to determine fitness. And I think what my co-panelist is trying to tell you is that why don't we therefore just stay with that? You're complaining of, you're making an issue about polluting the atmosphere. And the question would be, is that fact-based, facts traversed in the judgments and facts that we would have to traverse for our purposes? I think all she's trying to say is maybe you should try to avoid that kind of discourse.
Madam Chair, I will leave that for argument.
Thank you.
And if I may, I don't want to be misunderstood. I do not want you not to ask questions in relation to that case. It's just that I want us to be very careful, otherwise we'll and you know what happens. People pick what they want to pick about what the questioning is, what the evidence was, and the last thing you want is to create an atmosphere that might just not be helpful. And don't worry, we're going to try and ignore atmosphere. So if you could, please, don't bring it in. But you can ask questions relating to the case.
No, I was not going to ask any questions relating to the case. I was merely going to just to read certain passages and then then start with my cross-examination. But because they are public records, they are recorded, I'm quite happy to proceed with my cross-examination because it will not hamper me in any way in when it comes to making submissions.
And it might serve you better.
Thank you.
to do that. And you may proceed.
Thank you. Advocate Ferreira, when were you removed from the case?
If I remember correctly, there was an email sent by, and we dealt with it in evidence in chief by Advocate Mokgoro, asking Marshal Mogatle to appoint a prosecutor that was uncontaminated by previous events. You would remember the words uncontaminated. But I think it's in August 2012.
August 2012. And there are two advocate, I just want to clarify this issue. There is an advocate Mokgoro, and that will be the head of the of the Special Commercial Crimes Unit who took after you.
After Glenys Breitenbach, yeah.
Yeah, after
Yes, and
Glenys
the other one is Deputy National Director, Nomvula Mogatle.
Nomvula Mogatle. Is it Mogatle or Mogatle?
Yeah.
Is it Mogatle or Mogatle?
There's a slight difference in the spelling, I think.
Ke Khabu Mogatle.
Okay. I understand that the Deputy National Director is Nomvula Mogatle.
That's correct, yes.
Okay.
Sorry, shall we have the proper pronunciation for the record? And that's why I was trying to help
Okay.
you. Hai ke re ke Khabu. What is the proper pronunciation and spelling? M-O.
Oh. K-H. Okay.
Do you want to
It's
put it into the
M-O-K-H.
record?
It's K-H.
That is K-H-T-L-A.
TLA. So that is the National Director. The Deputy National Director. So that will be Advocate Mogatle. Is that correct?
You're pronouncing it Joanna, but it is written in Sepedi.
Sure.
So ke Mogatle.
Mogatle.
It's not a strong Mogatle. It's not like Mokgoro. It's not a strong pronunciation. It's a soft Mogatle.
Okay. And the
But I think focus on the spelling. Ne?
Mogatle. And the other advocate will be Advocate Mogatle. Am I right there?
These are two different names.
Okay, yes. So, after your removal, Advocate Mogatle, who took the position of Advocate Breitenbach, was appointed through a recruitment process. Would I be correct to say the position was advertised and then she was appointed?
Yeah, look, eventually he was appointed permanently in the position, but initially he just acted.
Yeah.
Because obviously until Advocate Breitenbach left, the position would not be vacant. So I can't remember how many years he acted. And when she was finally let go, or she resigned, the post was advertised and he was appointed. Unfortunately, I can't give you the date when the acting appointment changed to a permanent appointment.
And then I just want to, let's talk about Advocate Mashamaite. How senior is Advocate Mashamaite?
Look, he's no longer there. He went to the National Credit Regulator at
Yes.
a point, but he's a senior state advocate. Unfortunately, I can't remember now offhand his history before he joined the SCCU, but he's quite a senior, he's not a junior senior state advocate, if
Okay.
I can put it that way.
And Advocate Becker?
Advocate Becker he's deceased. He was a deputy national director, a deputy director, a very senior person. He was at one stage the senior prosecutor of Bloemfontein, and he was also with both Advocate Jiba and Advocate Mokgoro at, I think they call it the Office for Serious Economic Offences, headed by Advocate Jan Swanepoel. So he's a very, and he was at the Scorpions with them, both.
Okay. And Advocate Viljoen?
She's a senior state advocate, long time experienced as a control prosecutor in Johannesburg for many years. All people that acted there would know her. And then she came to our offices.
You see, just before I come to the reports, you said that in regard to the corruption charge, there was only one document which required declassification.
Well, I'm working from memory, so I
Yes.
might be wrong, but that's the only document that I can remember.
Yes. Remind us, what is that document again?
That's a memo written by, I think, I don't know what his rank is, but Lazarus, where he motivates for the buying or the purchasing of the 3 Series and 5 Series BMW that was eventually bought from Leo Heiser.
So on the 4th of December 2011, there was no declassification of that particular document.
I can't in all honesty now tell you whether that document was in the docket by the 4th of December.
Yeah, but what is? I don't follow your evidence. What are you saying?
No, that document I think existed and it had to be declassified, but I don't think it was in the docket by 4 December. We didn't need that document. If you follow me, we don't need that document to prove the corruption. That's what my viewpoint was.
And why did, if I understood you, you said the documents of the dealer, the dealer did not require declassification.
No, they're normal business records of the dealer. That's how I take it.
And this is the dealer that does business with crime intelligence.
Yeah, but these specific vehicles weren't purchased by the dealer from him. The only involvement he had in this particular deal was to loan Lieutenant General Madluli the money, or part of the money, and that was that. He did the 3 Series and the 5 Series were purchased from Leo Heiser, and the General's private motor vehicle, the 7 Series, were traded in at Leo Heiser. So there was no documents that you really needed from Atlantis, save for the acknowledgement of debt.
And which was dated?
If memory serves, about a year after the actual transaction took place, but I would rather, if it's an extremely important point, that one perhaps go to the document. I don't know where in the papers it is, but it's plus minus a year after. I think from one of the prosecutorial memos, maybe Advocate Ritas, she actually says that it's about dated a year later.
The documents relating to the shortfall, what kind of a document would that be?
Leo Heiser, who traded in the vehicle, the statement from 2 people from Leo Heiser, the dealer principal and a sales executive, would talk to that and said that there was a shortfall on the trading of the vehicle because the General owed more on the vehicle than it was worth trading it in for. And that shortfall was would be from the documents of Leo Heiser, because the shortfall was made up. And it was made up in 2 ways. One was the money that was paid over from Atlantis Nissan to Leo Heiser, and the other was the discount that were given on the purchasing of the BMW. Instead of giving it to the police, to crime intelligence, and reducing the purchase price of the vehicle, that discount actually went to make up part of the shortfall.
How do you know that?
It's from the documents.
What documents?
The documents in the docket and in our memo. I mean, if you look at my memo where we discuss the merits of the case, I referred to the relevant affidavits and all the relevant annexes to those affidavits. And you must remember, it's a long time ago, and I don't I don't necessarily know each and every fact from the top of my head, but it's in the papers. That's what I mean.
But you see, I'm not going to take this particular issue further with you because I initially indicated to you that, you know, prosecutors can interpret, you know, the facts in a docket differently, and there is absolutely nothing wrong with that. So I'm not going to pursue this particular issue with you, because all I'm going to put it to you was that at the time when Advocate Mokgoro made the decision after consulting with Advocate Mzinyati, he was of the view that there was no prima facie case for reasons that are stated in the memorandum dated the 4th of December 2011.
Yes, now I will agree with you, and I think for the other memorandums as well, of the different prosecutors, they exist. They before the inquiry can look at them. Different prosecutors had different views about what evidence was still outstanding and what evidence they should still obtain. And one important factor perhaps in my own mind is that to actually judge the decision made by Advocate Mokgoro and whether Advocate Jiba made a decision to not review or not to review, in my mind, the important documents are up until the stage that we gave the memo. Because if a prosecutor 2 years later has doubts about the honesty of one of the witnesses, that could certainly not have influenced our thinking or Advocate Mokgoro's thinking or Advocate Jiba's thinking in April 2012. So I take it to you that all of those documents are written by the prosecutors, and they say in those documents what they say there.
But it's
I think you're telling me that you're wrapping up.
He wasn't wrapping up, somebody else told him.
Now I was going to produce a document.
Wrapping up.
Yeah, no, I was producing a document. I'm not wrapping up.
So you need to wrap up. Actually, that's what I'm trying to tell you.
Wrap up for today.
Wrap up for today, yes. We don't sit beyond 4 o'clock.
No, for today I'm
For
done.
today, yes. You can wrap up for today.
Yeah.
You want to stop before you introduce the document?
Yes.
Or you want to interrupt?
Yes.
I think it's a good place to stop for today.
Sorry, Judge. May I just, as a matter of housekeeping and collegiality, to be fair to Advocate Maema, he subsequently reverted after we had commenced, and I thought it's only fair that we don't leave the inquiry with an impression that he has not bothered to respond. His response, which I will share with you, basically confirms my earlier address to you. He only expresses a reservation to communicate directly with the commission, with the inquiry, and he indicates that he would rather, both he and Advocate Smith, who made the decision, would rather Dr. Ramaite communicate the decision. So we have now established that there is a decision, and that's as far as I can take it, and the inquiry can decide how to deal with it. He responded at 14:07. Thank you, Judge.
I understand that you're saying there is a decision.
Yes, you'd remember in the documents handed up, he also confirmed that. I then wrote to him to press on to tell us what is the nature of the decision. He's now come back to say he is uneasy to say what it is, but rather let Dr. Ramaite tell the commission. So I was politely asking to disengage at this point. Yes.
That's fair enough. And thank you again. Okay.
Madam Chair, can we maybe deal with another aspect of housekeeping without trying to be... we have a witness coming in tomorrow who's flying in, Advocate Gerard Nel, and it requires us to lead his evidence tomorrow. Could we possibly... I don't want to ask how long you think you're going to be with Advocate Ferreira, but can we possibly interject Gerard Nel and then continue with Advocate Ferreira's evidence? Because we are not sitting on Monday and Advocate Nel has already arrived.
He had been scheduled for tomorrow morning.
He has been scheduled for tomorrow morning.
If you discuss it with Advocate Ferreira, would he be available after?
Chairperson, I am available tomorrow. I'm supposed to be in the High Court in Johannesburg for the long trial from Monday, but I am part of the team and I'm sure I can rely on the team members of mine to carry on Monday, should it be required.
We appreciate that. So you can go ahead and get Advocate now. I think it is all right. It is okay, isn't it? Advocate now is not available later. So it is determined how we're going to deal with the evidence leading tomorrow. Depends on the availability of the witnesses. Is that right? So Nell will be done first, and then we will continue with the Ferreira evidence, depending on when we're going to finish with Nell. Yeah. How long is he available tomorrow? Usually these things can't be predetermined.
If we could start at 8 or earlier, maybe not at 8, but if we could start earlier, that would be appreciated. I know it's, and I apologize to my colleagues, it's very hard to stop in the middle of a cross-examination or beforehand, but our logistics are going to be a nightmare. I'm trying to be honest, I can't actually recall the ambit of Advocate Nell's affidavit as we speak, but at the time when we planned, I didn't envisage him to be a longer than a day, but he may well be. So if we could start at 9, that could probably assist us.
That side of the room? Is 9 o'clock fine with you? Yes, thank you. Good. Okay, thank you. Thank you so much. We could start at 9 then. No, Advocate Rip is nodding his head.
No, I'm in order. I'm in Pretoria, so I can be at 9.
If no problem. Okay, thank you then.
We will be at 9, sorry.
We will be. Yeah, we will also, we are driving into Pretoria, but that is not so problematic, so we'll be available. So we can start at 9 tomorrow morning.
She started 9.
No, she's proposing the 9 o'clock. Nine o'clock it is tomorrow morning.
Short lunch.
No lunch? Okay, thank you. So thank you so much again, Advocate Ferreira, and thanks for your willingness to step aside a bit and give an opportunity for us to deal with other evidence, and your willingness to come back thereafter. It is much appreciated. Okay. Thank you. We adjourn until tomorrow, 9 o'clock. Thank you.